Okay, well, let's go ahead and get started. It's about 1 minute after the hour. I'm sure people will be joining later, but that's okay. Just make sure we're all set here. So just to introduce myself, this list, the invitee list went out to our plaintiff attorneys that we work with, and also Dave sent it out to his list. And so I realize that many attorneys that may be joining this don't know who I am. So just a brief introduction. My name is Greg Maxwell. I'm an attorney and a certified financial planner. I work with Amicus Settlement Planners. We're a firm that's based in Texas and Utah. We work with plaintiff attorneys all over the nation. Our focus is what we're a comprehensive settlement planning law firm. So what that means, we focus on income tax reduction strategies for personal injury attorneys, helping attorneys find ways through various means to defer and lower their income taxes and kind of grow their wealth on a tax deferred basis. We help PI clients preserve their government benefits. So if you've got clients on Medicaid, SSI, give us a call. We can help you work through those issues, get them into special needs trusts or whatever the case might be, to help them preserve those benefits at the time of settlement. And then we do structured settlement annuities and investment management for personal injury clients as well. So that's kind of who we are, Amicus Settlement Planners. If you have a question that we don't get answered on the webinar today, you can always email lien@amicusplanners.com, lien@amicusplanners.com, and that'll go to both Dave and to our firm, and then we can make sure that we get that question answered for you. So, but specifically today, the purpose of this webinar is attorney liability for clients' liens, Medicare, Medicaid, and ERISA. There's been a handful of cases that have gone around recently that have circulated through the plaintiff attorney listservs and that kind of thing, and I think have caused some confusion. So Dave today is going to help us kind of sort through all that, separate fact from fiction. I think there's, like I said, been some misinformation on some of these issues. So as we're going through, like I said, if you want to ask a question, go ahead and ask it. And if Dave doesn't answer it, we will answer it at the end. Or you can always email lien@amicusplanners.com and we'll get the question answered. So with that, I'll go ahead and turn the time over to Dave, who didn't want to show his face live because he's got a Sasquatch beard growing for coronavirus. But I'll turn it over to Dave, let him introduce himself, and then we'll go from there.
Thanks, Greg. That's exactly right. I'm coronavirus safe. I'm quarantined up. I hope everybody else is home as well and healthy, or at least being socially distanced. You're safe during this time. It must be really bad. There's nothing on Netflix that you're coming to watch a seminar on Medicare and Medicaid. But I'll try to make it as lively, as interesting as possible. What usually helps with that is asking questions about your own cases. So if I go over something, make sure you send a note. Greg will do a much better job looking at it than I will. Make sure I answer that question either while I'm presenting or at the end. So feel free to make sure you send those out the whole time. A little bit about me. I'm not doing a video, but I did update my profile photo to what it looked like, here in the house. So that's why I'm not on video. But I spent 15 years on the other side. I was an ERISA recovery attorney, covered FEBA plans, Medicare Advantage plans, Medicaid HMOs, disability plans. I worked for the law firm is Gibson and Sharps back then. They've actually now split up and become something else. But the company now is Equion, formerly Trover, formerly Healthcare Recoveries. After doing that for long enough that I couldn't look in the mirror, literally, I had to change sides. So now I'm on this side trying to make sure that the injury victim keeps as much money of their settlement as possible. I think how hard I started out being a defense attorney before I became an ERISA an attorney. My first client was Owens Corning Fiberglass. I was telling the world that it was really fiberglass that was bad and asbestos that was good. Those were tough days. So it's been a long evolution from that side of the fence to where I'm at now. But the one thing is true, fighting for your client is going to result in benefits on all these lien types. I'm going to talk about the exposure you have here on these different lien types, but I'm also make sure we talk about some strategies to address these liens. Because one of the things to remember is that these recovery vendors utilize ignorance and fear. They know this is a very niche area of practice. They know that after you settle a case, you're essentially working pro bono. And they want to use all of that against you. So we'll talk about how to be careful with your liability and your exposure, but that doesn't mean you be any less aggressive. Take it to these guys. Traditional Medicare, fee-for-service Medicare, point-of-service Medicare, Medicare Parts A and B. This is the Medicare you're dealing with CMS or BCRC, who is their recovery vendor, formerly MSPRC. They have been quite aggressive lately. I'm going to talk about some of the cases, but what had happened was for a while, till about 2014, there was a stay on Medicare prosecuting recovery collection actions. That stay got lifted and they were able to go forward with it. That's why you're seeing Pioneer Credit and people like that coming around now. They weren't allowed to do that for a few years, and that's why they're being more aggressive. Additionally, Medicare's out of money. We all know that. So how are they getting their money back? Well, the Department of Justice has really taking the trial bar to task on this exact issue. I do these kind of chronological order, but you see the first one here from Philadelphia is back in 2018. And the language from I think from the Department of Justice is important. So I'll go ahead and read it. When an attorney fails to reimburse Medicare, the United States can recover from the attorney, even if the attorney already transmitted the proceeds to the client. And this is the next phrase is every single decision. Congress enacted these rules to ensure timely repayment from the responsible parties, and we intend to hold attorneys accountable for failing to make good on their obligations. Remember, they're talking about being your obligation. The next year, again, we intend to hold attorneys accountable for failing to make good on their obligations to repay Medicare for conditional payments. This was in Maryland. This was a very large settlement, $250,000 paid out. There was a result of about 6 different cases where Medicare hadn't been repaid at all. So they resolved it by paying the settlement and then putting some other steps in place that we'll talk about briefly after the end of this. Later that same year, Science and Kirk, a very well-known firm in Baltimore, got hammered also. And see the second quote, we intend to hold attorneys accountable for failing to make good on their obligations to repay Medicare for conditional payments, regardless of whether they were the ones primarily handling litigation for the plaintiff. What happened here, they got co-counsel to handle the Medicare issue. They said, hey, co-counsel's problem, not ours. No. The way Medicare goes after individuals, including the injury victim, including the third party, including you, is by the broad definition of what is a primary plan or primary payer in the Medicare Secondary Payer Act. It specifically mentions attorneys and references regulation that specifically mentions attorneys as being have an obligation to repay Medicare. So it's not just your client who does it. You have an independent obligation. And they make it clear here that you can't hire an outside firm. You can't hire my firm and say, well, that's on Dave Place. Or you can sue me, which it wouldn't be. I have to pay you back. But I'd be important to pay attention to these vendors when you're outsourced to them. That doesn't absolve you of liability, either on Medicare or Medicare Advantage plans. You're still personally and your firm are personally liable. The prosecutions continue in Philadelphia this year. Another one that they haven't, look, remind the person, your attorney and others of their obligation to reimburse Medicare. Right there. Lawyers need to set a good example. And if they don't, we'll move aggressively to recover money for taxpayers. This was about $6,600. This was not a big one. This was a little one. And they went after them. Medicare is taking this serious. Everything's getting harder with Medicare. Anecdotally, about 2 years ago, the people handling the Medicare set aside review were getting about a $6 million a year contract from the government. The new Medicare set aside review team gets 60 million. So they're taking all of these issues very seriously. So I've been doing this for a long time. What I always hear from trial attorneys is, oh, my paralegal does this. Oh, well, she knows this really well. Well, I hope she doesn't leave. Hope she doesn't quit. Hope she doesn't get a better offer somewhere, because you're on the hook for it. What else is part of the settlement beyond the money? Those are big payments to Medicare, but what is the result? What is the Department of Justice saying you have to do to avoid this exposure? Honestly, it's very easy. Likely, you're already doing it. So all that fear we just talked about, very likely, your firm is already complying with this, which is simply have someone in your firm who's responsible for dealing with Medicare, make sure they're trained to know what they're doing, and have them do it. That's pretty much it. But don't ignore it. And saying just do it is easy to say. There's a very complicated process. You're dealing with BCRC, who incidentally is the Chickasaw Indian Nation. I didn't realize that. That's why it's in Oklahoma City. Anybody who's dealt with Medicare knows if you call them twice, you get two different answers. So saying just deal with Medicare is truly ivory tower thinking. So how do you just deal with Medicare? Well, the compliance factors are easily dealt with. I get the question all the time. Usually when it comes up, Dave, Medicare has told me an amount that I know is much smaller than I believe they paid in bills. Dave, what is my obligation to Medicare? Again, pretty straightforward. 3 easy steps to dealing with your obligation to Medicare. Your obligation to deal in good faith. That is met with 3 steps. First, advising Medicare of the potential for third-party liability, putting them on notice. Second, telling them of the settlement amount, accurately informing them of the 5 questions they want to know, which is the settlement amount, the liability settlement, the no-fault settlement, attorney's fees, cost, and settlement date. And then pay the final demand when you receive it. That satisfies your obligation to Medicare. Lying about it, talking about the injury being the wrong kind of injury, that's a problem. You have Medicare fraud. But if you tell them I'm suing someone for a broken back, L4, L5, and they don't include that on the claim summary, you didn't do any. That's their obligation to find that bill. Your obligation is to make sure they have the accurate information of what you're doing. So it's these, as Greg talked about, there's a lot of misinformation out there at how scary these things are. Certainly it's scary. Certainly you have to dot your I's and cross your T's, but that is what we do as lawyers. The steps are pretty straightforward. Vendors out there, myself as a law firm, there are non-law firm vendors that do this, who have good processes in place to help you comply with that. You just need to remember you're on the hook for it. So you've got to make sure that they're doing it honestly, they're not committing fraud, and that they're paying the bills that are supposed to be done. You see, here's the regulation where attorneys are specifically mentioned. And they're able to get twice the amount. I'm sure a lot of you heard about, and we'll talk about in a minute, the Medicare Advantage double recovery. That's only because Medicare can do it too. Medicare just doesn't. What Medicare does is they add interest. Then after, I think it's 420 days, they refer the case to the Department of Treasury. They start garnishing your client's Social Security benefits. Then they send off to Pioneer Credit, as one of the big credit companies, to go after your client. They are allowed to double it. They don't. Medicare Advantage plans will. We'll talk about those briefly. The single most useful tool in addressing Medicare's conditional payment interest is the Medicare Secondary Payer Recovery Portal, just called the Medicare Portal. You hear about it all the time. If you're not using it, you need to. Simple. You need to use this portal. It'll make your life so much easier. I know a lot of the more experienced attorneys who've been around a while got in the habit of using their client's My Medicare login. I understand why you did that, because there was nothing available before. The portal is much better. It's actually been around since 2014 with some updated functionality in 2016. You can do a lot on it. Yes, those of you who are on it will say it's a pain to get set up. Yes, it's the government process. You have to do a process online, then they email you some stuff and mail you some stuff, and it's just like that. But it is certainly worth the tiny bit of legwork and frustration of getting initially set up on the process and the software to use it. It is free. It is the only good thing I'll say about Medicare is the portal. I will talk bad about Medicare for the rest of the day, except for the portal. It is actually very useful. It is the exact same tool I'll use if you hire me or any other vendor that you're hiring. This is what they're doing when they're doing your Medicare work. You can do your full file management on there. You can report the case to Medicare. You can audit the bills, dispute the bills. You can send correspondence back and forth from Medicare. You can see when their next letter is going to come out. Like if you logged on today, it'll say their next conditional payment letter in your case is going to be mailed on May 3rd. That's nice to know that. You can get a pre-mediation final demand, final conditional payment amount. I don't know if you guys are aware of that or not. Now, I'll spend a little bit of time talking about that, but you're able to use the portal to get a final number for Medicare before you walk into mediation. There's always the problem before you had to settle your case at mediation, tell your client, well, I don't know how much we owe Medicare. Let me tell them the settlement amount and get their final demand. Then I can tell you what your case is going to net you. That can be avoided now using the portal. You can do appeals on the portal. The first two appeals, reconsideration, redetermination. Waivers, compromises, and refunds. That's right on the portal. You click a button and do it. You can upload documentation in support of that. You can write a narrative in support of that. These are the same things that any recovery vendor or any lien resolution vendor is doing. Now, of course, those vendors and myself have a lot more experience in doing this. And of course, I'm happy to do it for you. But there are a lot of times when you're able to do this with push your button yourself, save your client a few dollars, which we're all about doing, and get full compliance with Medicare, avoiding exposure for your firm and at no cost. It'll also list all the things Medicare has done, all the bills all the letters they've sent, all the transactions they've done, and you can get up to the minute claim amount. You log on and right there, it tells you exactly what their claim amount is in the liability file. If it's a premises case or a motor vehicle case, there'll be an open no fault file, and there'll be a big red flag at the top of the screen saying there is another active file with this claim, with this beneficiary's information. So you're not lost. Quickly on the no fault, there were several questions on exposure for the no fault portion on a Medicare file. As everything with Medicare, my answer is always 80%, because 20% of the time we don't know what the hell they're doing. But what has been my experience without exception, what I've been told without exception is as follows. The no fault is forever going to be the responsibility of the no fault carrier. You cannot submit information to the no fault file. Even if you send BCRC a copy of the no fault exhaustion letter, they will not accept it unless it comes directly from the no fault carrier. Here is the risk. What should happen is when Medicare is informed that no fault has been exhausted, then the balance on the no fault file should roll to the liability file, increasing your client's liability. That doesn't always happen. That is the risk out there, though. What should be happening, so what often happens is I get a call and say, Dave, I paid my liability file. I have the letter showing it's closed, but if there's an open no fault file, I'm concerned about it. What do I do? That is, again, the responsibility of no fault carrier. We have been told, and this is without exceptions happened, that they will never look to the beneficiary for that, even if it goes to past final demand, even when it goes to Pioneer Credit, which it does. They will continue to look at the no fault carrier, never to the beneficiary. Again, hopefully you don't, but if any has an exception to that, please let me know. What I like to do, try to get done in that situation, is they will not close the no fault file by any information we provide. However, if the no fault file balance is 0 and it remains open, then there's no exposure to a balance being rolled over into my liability file with me being unaware of it. So I work hard to try to get BCRC to roll those bills over. I want them in the liability file. Sometimes they don't want that because they get the full amount of that from the no fault care out without a reduction for procurement costs. Again, I'll talk about that more in a minute. But the no fault file I know can cause lots of confusion for the attorneys. The portal gives you access to both, so you can look at both of them, but the liability file is the one your client and you are responsible for. Quickly, here's what I was talking about the benefits of using the portal during mediation. It's a pretty quick process. If your case has already been reported to Medicare, it's on the portal, even if you're not on it yet. So if you get onto the portal today and you know you have a mediation coming up the next 4 months, you click this little button that says, I want to go into this expedited process. It's similar to a rocket docket in that once you're in, there's a couple benefits. One, you can only dispute one time, but Medicare must respond to your dispute within 11 days, or it's automatically granted, like a request for admission. But the real big benefit is the one I talked about the pre-mediation final conditional payment amount. You request that letter, the final conditional payment letter, and they will send you what you're seeing on the screen, which is a letter dated saying, for the next 3 days, this is the final conditional payment amount. This amount will still be reduced by procurement cost, but this number is final, so long as the case settles within that 3-day window. That way you can sit right at the mediation table and calculate up what Medicare is going to be owed. Now, when I talked about not rolling over when you have exposure, that really is key here. Audit and disputing is how you save money with Medicare conditional payments. That's why most recovery vendors in my firm do these on a flat fee basis, because it simply doesn't make any sense to charge a percentage of savings in a mostly administrative process. Auditing and disputing is making sure that only related care is included on your claim summary. A couple of things you want to make sure you're doing. If you're not using the portal and you're faxing things in or sending things via mail, don't use a highlighter. Medicare scans everything, highlighters don't show up. Also, if you're not using the portal, make sure you use a correspondence cover sheet. Otherwise, just a fax cover sheet, but otherwise Medicare is throwing it all away. If your claim is complex, you have a medical malpractice case, and the malpractice happened during a scheduled surgery. So the bills are complicated. The surgery itself took 8 hours instead of 4, but there's no way to break that bill up. Make sure you have some medical evidence to use that using your dispute. Medicare is looking they're looking for people basically to commit fraud. So anytime you have evidence to back up your position, they're kind of willing to accept the evidence so long as there is some evidence. Now, you saw on that previous screen a couple of things you may not have known about: hospital acquired conditions and bundled charges. These are probably 2 kind of secret ways to really impact the potential payment amount you owe Medicare. And again, these are what you're supposed to be doing. And by doing all this, you're staying in compliance and eliminating your liability. First is hospital acquired conditions. And frankly, this is good for your ethics and your duty to your client. This list of 14 conditions here are conditions which Medicare is not supposed to pay providers. So if you see these on your claim summary, you need to dispute these with Medicare, and Medicare will go back to the provider and get a refund and remove it from the claim summary. I often extrapolate from these. So it doesn't exactly say, once a slip and one falls in trauma, a certain code, another fall or trauma is very similar to that Medicare. We dispute that one as well. But that's their exact list. The other big issue when you're auditing is bundled charges. Again, this may be something your paralegals are familiar with and you're not. But when you get a Medicare claim summary, like you're seeing on the left side of your screen, there is one payment made, and then you see all those IC10, for instance, that first line, you see one $159 payment, and you see half dozen or more than that, 10 different codes there. That's 10 different treatments. What this California Insurance Guarantee Association versus Burwell case says is that Medicare is only entitled to be repaid for each individual charge that is later paid or become responsibility of another party. So if they bundle charges like they do here, and some of those charges are unrelated, meaning no party later becomes responsible for that charge, then it's uncollectible by Medicare. If it's uncollectible, Medicare can't collect it. So when they bundled it with collectible charges, the entire bundle gets thrown out, including the related care. Yeah. So related care will be removed from your client's claim summary. They will not need to repay it if it is bundled with unrelated care. I think it's important to realize that, because since we're talking about attorney liabilities, particular today, that may feel like you're playing a little fast and loose. You are not. The Medicare Secondary Payer Act is very specific, and this case is great on it. It's item by item. Just because they put a bunch of items together and make it one single payment doesn't change the statute. So this is an incredibly useful tool. If you guys talk to your paralegals about it, hopefully someone on the line, they know how common bundled charges are full of related and unrelated care. Okay. Repayment calculations. This is the amount you have to pay back Medicare when you're sitting at the desk with your final conditional payment letter and mediation. It breaks down pretty simple. If the Medicare payment is equal to or greater than your settlement amount or award amount, Medicare, you get your attorney's fees and cost, Medicare gets the rest. Your client gets nothing. If Medicare payments are less than your settlement, then the Medicare repayment is reduced by procurement cost, which is essentially attorney's fees and a pro rata share of the cost. Procurement costs, though, what are they? You hear about that all the time. A couple of points. Well, I was talking about no fault earlier. They only apply if the claim is disputed. So no fault does not get reduced. That was why on this final settlement detail document, which is the document you use to report to Medicare, it asks specifically liability settlement versus no fault payments for that very reason. And then obviously the cost. Now, if Medicare has to come and file suit, they are not going to reduce their procurement cost. So these are some important things to remember when you're dealing with Medicare. You're getting that reduction because you're agreeing to repay Medicare. If you're ignoring Medicare, as firms did earlier, you don't get that reduction for procurement costs. You're the whole amount. Okay, enough bad news about Medicare Parts A and B. Let's have some bad news about Medicare's Part C and D. Moving down the alphabet. Essentially, it's the same bad news. These are Medicare replacement plans. When I first started, these were called Medicare Risk HMOs. They're often called MAOs, Medicare Advantage Organizations. I think a trial bar most often calls them Medicare Advantage plans. They're essentially replacement plans. If your client is on Medicare Part C, it replaces Medicare A and B. There's some funding issues about that, but that's essentially what happens. Part D is obviously prescriptions. It doesn't replace, but it does have the same recovery rights as A, B, and C. Now, Medicare Advantage organizations, I'm a big fan of them. I think they're great. It's back to the bipartisan era of Gingrich and Clinton. It's funny just to say that, but that's where it comes from. Too many baby boomers and too many for Medicare. So a union of government and private industry came up with Medicare Advantage plan, and essentially Medicare run by private industry. They get paid a fixed per diem by the government, and they're able to use a risk pooling like Obamacare to charge premiums beyond that. That's what's going on with that. This is different than Medicare supplement plans or Medigap plans. And there are essentially 10 of those in various states. They all go by different numbers, different names, or different letters. F, G, K, L, M, and N are some common ones. These supplement plans are private insurance. They are governed by state law. So if you're in a state like Virginia and your client has a Medicare supplement plan, anti-subrogation applies, they have no recovery rights. That's important to know the difference. And I understand the real problem here, the real exposure for you as an attorney here is figuring out what plan your client's on. I always use the example of my in-laws. My mother-in-law is on Medicare, traditional Medicare A and B. My father-in-law is on Medicare Part C. You ask them both who their insurance carrier is, Medicare. Even though my mother-in-law has, Medicare, she has the prescription card, she has the Medigap. So it's confusing, and often you're dealing with seniors who can often be easily confused, especially if they've been involved in a personal injury, a traumatic situation. So it's important for you and your team to really do the legwork on saying who paid the bills, what insurance cards does your client have. Everybody who becomes 65 becomes Medicare eligible, gets their red, white, and blue card, even if they don't use the red, white, and blue card. These plans' recovery rights, Medicare. The big distinction is how they're going about enforcing it. Humana in particular, I can just envision this little 27, 28-year-old lawyer who read this statute, was trying to convince his managing partner to prosecute these cases based upon a 1980 statute that hasn't changed and no one had ever done it. And he finally convinced somebody to do it. And now, boom, millions and tens of millions of dollars later, they're doing it everywhere. Essentially, Medicare Advantage plans are not charging interest. They're doubling the amount due. The Paris Blank case here in Virginia, I was an expert witness in that. That was, at the end of the day, their claim was $400,000 from the firm that never even went to the plaintiff. Thankfully got resolved, great attorneys there. But Humana in particular is lying in the shadows, waiting for you to make a mistake. They truly are. It's a profit center for them right now. So dot your I's, cross your T's, call myself or Greg with questions. I think sometimes people feel dumb asking dumb questions. Every question's dumb. If you don't know the answer to it, if you know the answer to it, why you're asking it? So you should ask questions you don't know the answer to. If I don't have the answer, I'll find the answer. Same with Greg. Medicaid is quite a bit different in the way you're exposed to liability. And one of the questions I got was the question I always get: do I have to put them on notice? My answer is going to be yes, put them on notice. There are about 8 states that don't have a specific notice statute that says you must put the Medicaid agency on notice. But almost every state has an automatic lien. When Medicaid makes a payment, they have a lien. They don't need to perfect it. They have it. Some states require some perfection. Every single state, though, imposes some form of criminal or civil liability for not repaying Medicaid. So I don't see the benefit of not putting them on notice and exposing yourself to criminal liability for it. That's why put them on notice. Don't be afraid of them. There's no reason to be afraid of Medicaid. And it's keep remember Medicaid recovery vendors, the Rawlings of the world, Trovers, Equions, they are all data mining companies. All they've done is monetize it in the form of subrogation, but they're just data mining. So they're gonna find you. What's your exposure? Well, each state is a little bit different on how they expose attorneys to liability. Some is direct liability. Some is exposing you on the idea of they can void any settlement. So you're exposing you to a claim from your client for malpractice. And they realize that. They will go after you for bar complaints. You dispose of money, we know a third party has a claim to it. Florida is a great example. I did a lot of work in Florida. And I saw lots of letters from Florida Medicaid. And in my last bullet point, you can see the brackets, I put fraud and theft, robbery. In the letters, they just reference the statutes. So you get the statute number down there. You may think it's some administrative code referenced in this boilerplate letter from Conduit. No, they're telling you, attorney, if you don't pay us back, we're gonna come after you for fraud and theft. They're serious. So again, I don't know why you wouldn't want to put them on notice and say, I feel like you got over on somebody. Deal with it head on. I guarantee you, there are great vendors out there, firms like myself, or great people in your office who can handle this in a professional manner where you don't have to feel like you're exposed yourself to any kind of liability down the road. I would just put them on notice. And why I say not to fear them in particular is because of Alborn and Wass. Now, there was confusion for a few years because during the fiscal cliff negotiation under Obama, some language got changed. And frankly, the AAJ fought for years to get it fixed, and it was fixed. So we're essentially back where we were, which is not in a bad place. Essentially, what they say is only the portion of the settlement that is for past medical benefits provided is available to the Medicaid repayment claim. That's what it says. So if your settlement has pain and suffering and lost wages and futures, that portion of the settlement is unavailable to Medicaid. Now, some states like Florida completely ignore that. They pretend the Supreme Court does not exist. I realize that. They're wrong, and I know that doesn't make your life any easier. But even in Florida and in other states where this is true, Virginia can be quite difficult as well. You're being entitled to have a hearing on that exact fact-based question. So when you're prosecuting your case from the start, you're going to want to make sure you build your case in that way that you can easily evidence at the end that, yes, I got a $25,000 settlement and there's $50,000 bills paid by Medicaid. But that doesn't mean all $25,000 is for Medicaid's bills. This person also has lost wages, and go through that. And obviously it's easy on a jury award. We have a specific jury question on point, but we don't want to go that far. We want to get these cases resolved before then. But build as much of that as you can in your case to show the recovery vendor, if there is one, or the Medicaid agency that where their rights end. Again, you're limiting exposure, but that doesn't mean you have to throw the baby out with the bathwater. Keep pushing back on these lien types. Last one we'll go over is ERISA, everybody's favorite, the Employee Retirement Income Security Act of 1974. This is a bit new. This Longberger case listed here has been out for a while, but the big distinction in Longberger was, one, it was a standalone case, and the attorney there had agreed to honor the lien. The Publix case and the Dillo case are much newer, much more troubling. They're not necessarily confusing or surprising given the way ERISA law works, because ERISA essentially creates a, quote, equitable lien by agreement. So the settlement funds or award should be thought of as a physical piece of property that exists physically, not in some temporal space. So the key is in dealing with this is, where is the money? For 20 years, what the court has been saying. Back in Knudsen, which was ironically or coincidentally was the first case the Supreme Court heard after when they reopened after 9/11. We're talking about here another pandemic. I remember being there for oral arguments, and DC was just empty. It was spooky, as spooky as it is now. But what they said in Knudsen was, the person who's in possession and control of the funds is the properly named defendant, whether that be a bank or the court. We put the money into the court's account, a trust, holder of an annuity, the beneficiary, not the owner, individuals, and now it's seemingly the trial attorney. So I was sitting in the Montanil oral arguments, and I actually just been admitted to Supreme Court. I was pretty excited to be sitting on the other side of the bar. And Justice Breyer made my chin hit the floor when he asked one of the questions, interrupted one of the attorneys from National Elevator, said, well, why can't you go after the attorney? We know where some of the money is. Can't we go after him on a theory of fraud? Oh my God, I about died. Thank goodness that language appeared nowhere in the decision. Unfortunately, I wasn't the only one who heard that. And now you're having these district courts enact that rationale, which is the funds are what we're after. Where are the funds? So if you hold them in your trust account, you're an available resource. Sorry. Okay. How do we keep fighting back though? How do you fight back on this? Best practices. Send the 29 USC 1024B4 letter to the plan administrator. It's a simple letter. It goes to the plan administrator. That's going to be the employer. If you don't know who the plan administrator is, it's quite a lot of questions. Dave, I don't have any insurance language from my client. Who's the plan administrator? The employer is always the plan administrator unless they designate a third party. And the only time you ever see that is when multiple union shops get together, buy a multi-employer policy, and then designate typically the union trust as the plan administrator. But what you're looking at now is what I asked for. This was on my template letter. I have a one-page letter. It says, hey, give me this stuff. It's under the statute. It's everything. It's important. It's probably it's singularly the most important you do is send this letter out. One, you get the documents you need. And two, it puts some leverage on the plan and the recovery vendor to negotiate with you. The penalties, the statute gives penalties of $100 a day after 30 days, and the regulations move it to $110. So when you send the letter out, make sure you reference $110 a day penalty. When I was on the other side, I could always tell when there'd been a CLE on ERISA because I get a letter from an attorney threatening a $100 a day penalty, and I knew he didn't know what he was talking about. So make sure you reference 110. Excuse me, not Corona. A few cases are listed here, but essentially almost every week or every month, a case is coming out where these penalties are being assessed. So again, it creates leverage. It puts you in a stronger position to deal with the ERISA plan. And also you're doing your due diligence for your client. So you're giving a higher quality legal representation and you're protecting yourself from exposure. Now, I want to talk about, as my last slide, so quickly, the limits of the extent of your exposure to an ERISA plan. Those cases we talked about, I'll go back to them so we can have they're not happy to provide this material. The Dillo case in particular and the Publix case. The fact question is, where is the money? So in those cases, what they won was the ability to do an accounting of the law firm. Where are these funds? And the question in all the other cases that follow Montanil, both against the plaintiff and these cases, is were the funds spent on non-traceable assets or were they commingled? So taking funds from a case, they commingling with your general operating account or your IOLTA account is not going to extinguish the ERISA plan's recovery rights against you. The only way to do that is specifically provide evidence that the exact dollars, remember it's a physical piece of property, have been either given to the attorney as a rainmaker or spent on something or just gone. They're no longer in the possession of the law firm or the lawyer, and they're not being put into this kind of law firm trust account that can be easily accessible. They are spent, and the property has been destroyed. That's pretty hard to prove. Most attorneys do not. I don't know a single attorney has a separate account for every case they settle to evidence that. Most attorneys do exactly what they know you do, which is take the money, put your general account. It's easier for a client to put their settlement funds in a separate account and then provided evidence of that being spent than it is for you. They know that. That is why you're seeing more cases of them coming after you. And I learned a discussion this week I settled on this on Monday, and the attorney's getting sued, and the optimist sent the case out to their local counsel to start litigation. And the issue was, I know this attorney can defend this case himself with your support, Dave. But does he want to do that? Isn't it a loss of productivity and time for him to do that? Shouldn't he just pay X dollars? And at the end of the day, the business decision was he did pay X dollars because it was a waste of his time and effort to fight this litigation against this ERISA plan. They understand that. They're bringing all these points of pain to bear against you. So make sure you're dotting your I's, crossing your T's, not giving them an easy way to put exposure, especially on Medicare. Make sure you're watching it. Medicaid, put them on notice and deal with it. And ERISA, make sure you're satisfying that lien before you disperse the funds to your client.
Excellent. Well, thanks, Dave. That was a great presentation, great overview. While we're still on ERISA, how do you know if it's an ERISA plan or not? I mean, is there some, I mean, how can firms know if they're dealing with ERISA or not?
Sure, absolutely. I get that question all the time. And in fact, it's the most common question I get is, Dave, I think I have an ERISA plan. ERISA sounds so scary. In some of my presentations, I have my ERISA slide is a picture of Godzilla tearing up Tokyo, because that's, trial attorneys think about ERISA is going to do to their case. ERISA simply means employer. If your client receives their insurance through their employer, it's an ERISA plan. The exception to that are, if they're a federal employee, it's likely a FEBA plan. If their employer is a church hospital, or church school, state agency like a clerk or a sheriff, then they're going to be accepted from ERISA. So they're not going to have ERISA preemption. The real question is how is the ERISA plan funded? If it's a fully insured ERISA plan, that's normal insurance. State law applies. It's ERISA, but it's fully insured. It is insurance. Self-funded ERISA plans are ones where the company themselves, either their own assets, their own contributions, and contributions from the employees, fund their own claims. That is treated as not insurance and is governed by the special, scary, self-funded ERISA rules. Now, that is an increasingly large group of plans. 63% of all employers now have some self-funded component. The big reason is it lets them avoid lots of premium costs and accept themselves from lots of regulations. So you're seeing more self-funded plans, but your question is always about the funding, not whether it's ERISA or not, because almost all plans are going to be ERISA.
Okay. And you talk about this 1024B4 letter, a template that you always send out. Can we send that out to all the registrants, just a template 1024 letter for them?
Absolutely. More than happy to send that out. And those of you who do this will feel like you're doing small ball, because it's just a letter saying, send me these documents. You will be amazed at how powerful that letter gets. Because what happens, it goes to the plan administrator, not to the recovery vendor, not to the TPA. So it gets their attention. I highly recommend sending that letter every case. Okay.
And then that template letter will let them know whether it's a self-funded plan or an insured plan, or it gets
Correct.
them. Yeah. Okay.
They'll respond back. They're required to respond back with all the documentation. Quite frankly, in the documentation, either summary plan or the master plan, whatever they send you. And I have a whole other presentation on ERISA, so I'm trying to get too in the weeds.
Right.
There will be a section either on the first page or the associated page called administrative page that will say how the plan is funded. And it will say something, it may say this is not an insured plan. It may say it's a self-funded plan or self-insured plan, or it'll say this plan is funded by the general assets of the company or by contributions from the employer and employee. Those are kind of all the magic words that mean it's self-funded.
Okay. Okay, good. We had several questions on that, so I wanted to ask that. We do have some questions here that you've submitted. I just want to go over a few of them. They're all kind of grouped into different types. So one specific question I want to ask you, Dave. One says, I placed Medicare on notice of a claim within a month of the accident in 2017. Several months later, they sent me written confirmation that the case was resolved and they were closing their file. The case settled a month ago, the funds were all dispersed, and the claimant passed away last week. I just received a letter from Medicare on the same case with a new case number asking for reimbursement of $30,000. I wrote to them explaining what had happened and attached their original letter. Am I on the hook?
Well, first of all, easy questions are also acceptable. That is a complicated fact
Right.
pattern, but you get that quite often with Medicare. Again, you deal with elderly people who do pass away from related and unrelated reasons. And you deal with Medicare who seems to not be able to do the same thing twice in a row. A couple things happen. First, when that happens, always make sure that you're looking at the account numbers, the date of accident, to make sure they're talking about the same file. Sometimes they're not. I think likely what happened was the defense is required under Section 111 reporting to report every settlement of a Medicare beneficiary to Medicare if it's over $1,000. They do that typically 60 to 90 days after settlement. If Medicare is made aware of a settlement by someone other than a beneficiary, they enter what's called the conditional payment notice period. This is a unique period, different than a final demand period. In the conditional payment notice period, they'll send a letter to the beneficiary saying, hey, we've been put on notice of settlement. Here's the conditional payment amount we've made. Unless we hear from you within 30 days, this conditional payment amount will become the final demand amount. What usually happens is beneficiaries do not contact their trial attorney. They throw that letter away. It's like all of them, they rarely do that. So almost always the conditional payment amount, the conditional final notice, the final conditional payment notice amount becomes the final demand amount, unreduced for attorney's fees and costs. Then you have to file an appeal to get your attorney's fees and cost applied to that. I understand you don't want that situation here. But that is likely what has happened. So you need to, and you're already on a process dealing with Medicare, providing the information about their previous letter saying the file was closed. Medicare responds very slowly to things. So they're probably processing your letter and getting a response to it now. I'm not saying it's going to be favorable, but they're probably doing a process now. They're not going to move quickly on that. But you're going to, if the date of loss is correct and your beneficiary is correct, it is a claim you're going to need to deal with. Even though the beneficiary passed away, the estate's going to need to deal with it if a state's been set up.
Okay. Yeah, and a lot of these questions are pretty case specific. So again, if you have a question, feel free to email it to lien@amicusplanners.com, and then Dave can give you a call or work with you directly on your case, your fact pattern. One other question, Dave, is there such thing as a list of CPT codes for which Medicare does not recover?
Yes, there is.
And is there a way to get that list somehow?
The list is right on my screen. I'll make sure to have it to you. It's not a very long list, obviously. It's just this list right here. And they're called hospital acquired conditions. The idea being that the hospital made your client sicker, means surgical site infection. Okay. Medicare is not paying the hospital to make your client sicker. But if they did, it will appear on your claim summary. So make sure you get that audited off, and it's a big benefit to your client because somebody's paying Medicare back and it's not you.
Yeah. Okay.
And there is also the link to that list as well.
Okay, perfect. All right. One question we get all the time with these, and there's some confusion out there. Medicare has, of course, their conditional lien, which is from the date of injury to the date of settlement. And then there's the issue of what Medicare's rights are in terms of future payments. And I know we didn't really talk about that in this seminar, but all of these double damages and things that you've talked about here with Medicare, that all applies to the conditional lien, or the lien from the date of injury to the date of settlement, correct?
Correct. And a great way to think about Medicare set-asides are not my specialty. I know quite a bit about them. It's enough to be dangerous.
Yeah.
But the way to think about that is if a Medicare set-aside issue arises, it means Medicare didn't pay for something. So they haven't been out any money. So that, and then your client calls you and says, hey, why didn't you tell me? But Medicare didn't cost Medicare anything. So all these double damages are for payments Medicare has made and another party later became responsible for, and Medicare was not repaid. You have 60 days to make that payment.
Okay. Yeah. And if you're curious about what your obligations are to Medicare post settlement, feel free to give us a call or email us. We can help you walk through the facts of your case and determine, look, maybe you should set up a formal MSA, or maybe you don't need one, or maybe you can just do an internal letter to the client, explain what the worst case scenario is, and make sure you document your file. There's lots of different approaches to protecting Medicare's future interests. So give us a call. We can help you walk through that and kind of maybe help you think through that. But everything Dave's talked about today is the conditional payment, and not the future Medicare's future interests. So just wanted to make that clear. You know, that's kind of the general, you know, we have various case specific questions, but I think those might be better just emailed to you, Dave, and then you can reach back out to the clients. I think this was great information. There is a lot of misinformation out there that this cleared up for me. And again, we work with Dave. We're a comprehensive settlement planning firm, but one thing we don't do is lien resolution. We dipped our toes in for a while and realized, I don't want to do this. And so we send all our stuff, and we partner with Dave for a reason. And that's because he's extremely good at what he does. And Dave, one question we do have, I want to make sure you answer. Can you just explain briefly how you charge if someone wants to outsource this? They don't want to train a paralegal, or they don't want the headache. How do they outsource this to you?
Sure. Thanks, Greg. Sure. Medicare, in particular, we do a flat fee, $500 for Medicare. That's us reporting the case to BCRC, getting it set up, doing the auditing and disputing for you. When you're getting ready for mediation, we'll handle getting the final conditional payment letter for you, so you have that mediation. And one thing I didn't mention there was, if the case doesn't settle at mediation, or you miss those deadlines, that sped up process, you're just kicked out of the process. There's no negative impact. You're just back to the normal Medicare process. And we do all that for a flat fee of $500, all the way to getting the final demand. Everything else, whether it be FEBA, ERISA, disability plans, hospital provider issues, we do all of that on 10% of the savings is our fee. So if we save your client, $5,000, our fee is $500. There is a $500 advance fee, a minimum fee, you'll send to us when you refer the case. But if we don't save your client at least $500, we refund that money. So your client should always be better off hiring us.
Right. And that's the point I try to make, is it's a no-lose situation. And in fact, you will allow, I mean, in some cases, I know I've referred clients to you that have done their best with an ERISA lien, for example, and then call you in, and you only take your 10% of whatever you're able to kind of improve on what they already did.
Absolutely. Absolutely. And that's also true of Medicare Advantage, because Medicare Advantage, unlike regular Medicare, we do charge percentage of savings, but we don't charge the 10% on the statutory reduction. So when Rawlings automatically knocks off the procurement costs, as they should, we don't charge a fee for that. They're just doing what they should do. We don't charge a fee for the improvement we make beyond that. Yeah. And another thing I want to stress too, Greg, I know you're the same way. I don't charge for email questions or phone calls. If you have a question, or you need a little bit of advice, give me a call, shoot me an email. I really don't want you struggling over an issue that I may have an answer to at the tip of my fingers, and you've spent 3 weeks trying to find an answer.
Yeah, exactly. I mean, I think half our day is spent on the phone and in emails, just working with trial attorneys and PI attorneys, just helping them get through certain issues. You focus on the liens. If they've got clients on Medicaid and SSI and they just have a question, we're happy to just chat with you about the situation. We're not going to send you a bill. So yeah, so Dave's your resource, or Amicus, or lien at amicusplanners.com, or call Dave directly. He's the resource for everything lien related. Your clients are on benefits and they want to preserve those benefits. So if they're on Medicaid and they want to stay on Medicaid post-settlement, that's when you give us a call, and we can help you work through the various options that you have, whether it be a special needs trust or a spend down or whatever it might be. But yeah, feel free to give us a call. We will send out the materials of these slides that Dave presented with contact information, as well as that 1024B4 letter, that template letter for ERISA plans, so that you can refer back to them and have the links that Dave posted. But I think for now, we'll let everybody go. It's that was about almost exactly an hour. So we'll let you get back to Tiger King, and we'll go from there. Dave, do you want to say anything right at the end here to finish up?
No, thanks everyone for your time. I really appreciate you being here today. I said there is a new episode of Tiger King, the follow-up, so make sure you track what they're doing.
All right, great. Thanks everybody. Stay safe. Hope everybody's safe and healthy, and we appreciate you being on this webinar. And thank you, Dave, for your time and for your willingness to do this.
Thanks. Bye, guys.
See ya.